If it pleases the court, Your Honour, my name is Kerslake initial N, and I appear for the applicant Mr. Johnny Wishbone, who is facing 106 charges today. My client is a juvenile who is of Torres Strait Islander descent, who was born on the 29th of June 2000. I have some written material which I would like to tender to Your Honour. This material has already been submitted to the Crown. Your Honour, I make a submission as per section 590 AA of the Criminal Code, today seeking a pre-trial ruling on a number of issues of evidence which I submit are inadmissible. My case is based on what I believe to be numerous breaches of the Police Powers and Responsibilities Act and the Police Powers and Responsibilities Regulation. I hereon refer to these as the PPRA and the PPRR. My client, Mr. Wishbone, was arrested at the scene at number 2 Smith Street, Suburbia, after being questioned by police. He was then driven around by police officers in an unmarked car while questioning was undertaken. He was then driven to a police station and further questioning was undertaken. My first argument is that section 418 was breached by the arresting police officers. My client is a juvenile, and as per section 418 of the PPRA and section 421, if the officer reasonably suspects that their interviewee is a person of 17 years old and under, the person is required, where practicable, to speak to a support person. It is evident from the police radio transmission that the arresting officers were aware of my client's age. My client was not afforded a support person when he was questioned in the car or at the scene, and he was not advised that this was a requirement. There was no effort by the arresting officers to contact a family member or support person before the questioning began in the vehicle and at the scene. It was not until my client was interviewed at the police station that a support person was provided. This support person was identified as Donna, a social worker whom my client had never met before. This contravenes section 421(2), which states that before the questioning starts, the police officer has, if practicable, allowed the child to speak to a support person chosen by the child in which the conversation will not be overheard. My client did not choose this support person that was present. There was no suggestion that this was a time-sensitive matter or that my client was going to flee. Therefore, this was practicable to find a support person. Your Honour, my second argument is that my client is of Torres Strait Islander ethnicity, and this is not taken into account when my client was questioned. Section 420 of the PPRA stipulates that if the police officer reasonably suspects the person is an Aborigine or a Torres Strait Islander, that the police officer must inform the person that a representative of a legal aid organisation will be notified that the person is in custody for the offence, and as soon as practicable, notify or attempt to notify a representative from that organisation. The arresting police officers did not undertake these steps to protect my client. They did not even mention to my client that he was afforded this right. My third argument, Your Honour, is that section 436 of the PPRA was not complied with. When any confession to an indictable offence occurs, it is required that this confession be electronically recorded, if practicable. The confession was taken in a police vehicle and was not recorded by police officers. I submit that the vehicle may not be considered a recording facility as dictated in the Act. However, as there were multiple officers in the vehicle, all of whom most likely possess a police radio or a phone, the court should consider whether this electronic recording was indeed possible and practicable. I further submit that as per section 437 of the PPRA, if the confession is not recorded electronically, a written confession can be admissible if the suspect is presented with this document to read and to make any amendments. Your Honour, this was not undertaken at the time of the confession or when my client was questioned at the police station. My client was not given a copy of this. Your Honour, in summary, my client is facing 106 charges today. My client is a juvenile, a member of the Torres Strait Islander community, and has not been afforded the fairness that Section 130 of the Evidence Act dictates. I submit that the evidence's prejudicial effect outweighs its probative value. I have submitted to the court multiple breaches of a PPRA which protects the vulnerable to miscarriages of justice. My client, a juvenile, was interviewed without being cautioned, without being advised he required a support person, and without providing a support person of his choosing. Your Honour, I submit that these 106 charges be dismissed on the inadmissible evidence discussed today. I refer to Bunning and Cross and Island's case that yes, there is a public policy argument to convict those who have committed criminal offences. But there is also a public interest to protect an individual from unlawful, unfair treatment. My client has been subjected to this treatment. Thank you, Your Honour.